continue the matter to circuit court for further negotiations regarding sentencing.
And that's accurate, Your Honor. The people also unconditionally waived the right to a preliminary examination and asked that the case be found over as charged. And then our offer for Mr. Gonzalez is for him to waive up to the circuit court as charged, and then at the first pretrial conference, plead guilty to count 1. After he pleads guilty at the first pretrial conference, the people would dismiss the remaining counts. The offer will close at the conclusion of the first circuit court pretrial.
Okay, Mr. Gonzalez, can you hear me?
Yes, ma'am.
Okay, you understand that you have the right to have a preliminary examination in this matter here in the district court.
Yes, ma'am.
You understand that you have the right to require the prosecutor put forth evidence that would support that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime.
Yes, ma'am.
Are you willing to unconditionally waive your examination?
Yes, ma'am.
Is anybody threatening you to get you to do that?
No, ma'am.
Has there been any promises extended to you in exchange for you waiving your exam?
No, ma'am.
Oh. Bind over date's gonna be April 10th. That's the date that the circuit court's gonna get the file from the district court. That's not a date that you need to appear in court, okay, Mr. Gonzalez?
Okay.
Your next court date is going to be a pre-trial in circuit court. Mr. Etheridge will be made aware of that. You stay in contact with Mr. Etheridge, okay?
Yes, ma'am.
Your address at the time of your arraignment, you stated that you would be staying with your brother on Miller. However, last week, the alleged victim appeared before me, indicated that she was no longer at the address on Jennison. So is that the address that you're staying at now?
Yes, ma'am.
Okay, so we'll make sure your mail goes to that address. And then you are on a 10,000 personal recognizance bond with GPS tether that will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor. Mr. Gonzalez, you and I talked yesterday about the change of address. Make sure you tell pretrial services your new address, okay?
Yeah, I already contacted them and left them a message with the address, and they haven't called me back yet, but I did leave the message and I gave them the address.
Okay, thank you, sir. Nothing further, Your Honor.
Thank you. You're all set.
Have a good weekend, Mr.
All right, thank you.
Yes, sir.
Thank you. Mr. Mills, you here with Mr. Christie?
I am, Your Honor, yes.
On the record in the matter of the people of the state of Michigan versus Matthew Christie, file number 24-00809. Appearance, please.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good afternoon, Your Honor. Stephen Milks on behalf of Mr. Christie, who is present with us via Zoom at this time.
Mr. Christie, can you hear us?
Yes, I can.
Okay, very good. Today's the date scheduled for a probable cause conference. Let's see. I don't have the file. Matter is scheduled to proceed to preliminary examination April 5th at 9 o'clock in the morning. Are we continuing to exam?
Yes, Your Honor, we are continuing the exam at this time. There has been a plea offer that was extended, and I did have the opportunity to speak with Mr. Christie previous to today's hearing. But we'd like to leave it out at this time. If there's any change, obviously I'll relay in the prosecutor's office know before the prelim next week.
Very good. Let's see. Bond was set at 2,510%. Let's see. Any other matters for the record?
Nothing from the people.
Nothing with defense, thank you.
Thank you. You're all set, Mr. Christie. We'll see you next week.
Thank
So big, but
Okay, let's see. Who do we have?
Give Mr. Blackman
I can't see anybody back there. I thought I removed that chair.
what do you want?
I can't see anybody when they sit back there.
Blackman's hiding from me.
You
Okay.
can't yell at us too, though. So,
You said what?
you just can't yell at us, so that's why.
Well, then you just sit there for a long period of time because I don't know what's back there.
Sometimes that's why we do get yelled
On
at.
the record, in the matter of the people of this state of Michigan versus Javier Jimenez, file number 24-00760, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Fred Black on behalf of Mr. Elvis Jimenez. He's standing to my right at the podium.
Okay. Let's see, how are you, sir?
Good, how about you?
I'm pretty good. Okay, how are you, Mr. Blackman?
I'm good.
Today's the date that was set for a probable cause conference. The matter is scheduled for preliminary examination. April 5th, 8:30 in the morning. Are we continuing to exam?
Well, you go right ahead.
Oh, it was my understanding that Mr. Jimenez would be accepting our offer and waiving up to circuit court.
Place the offer on the record, please.
Our offer for Mr. Jimenez is to waive up to circuit court as charged in the first pretrial conference, plead guilty to count 2, carrying concealed weapon with the people's consent to HIDA. And then after he pleads guilty at that time, the people would dismiss the remaining counts and the offer will close at the conclusion of the first circuit court pretrial.
Okay, that's complete and accurate.
That is, John, I full complete statement, and I've talked to my client about waiving the thing.
Okay, so Mr. De Jimenez, you understand your right to have a preliminary examination in this file?
Yes, ma'am.
And you understand your right to require the prosecutor establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You wish to waive this unconditionally today?
Yes, ma'am.
Is anybody threatening you to get you to waive your preliminary examination?
No, ma'am.
Has anybody made any promises to you if you waive your exam?
No, ma'am.
Thank you. Your bind over date is going to be April 10th. That's the date that the circuit court will get the file from the district court. You do not need to appear in court on that date, okay, sir?
Okay.
Your next court date is going to be a pre-trial in circuit court. Mr. Blackman will be notified of that date. We have an address for you in Holt. Is it Delvino?
Davlin?
Davlin, okay. Davlin, apartment 3,
Yes, ma'am.
okay, and phone number ending in 9911. Okay. Was set at 10,000 cash surety with GPS tether and a no contact order in place for the protection of a Hector Fasada Zavala. That will continue. Any additional matters for the record?
Judge, just 1 minute if I might. One of the conditions bond is a tether. My client has no prior record and the court sees what he's going to be pleading to his mother's in the courtroom. He lives with her. He's starting a job at SPAR this next week. She's like, and she's indicating it's expensive per week for the tether, and there's been no violation since his original agreement that he had. So he had finally the court indicated, and that's the court to consider removing the tether. He's
Thought
been
he already
recording
worked
also.
at SPAR.
Pardon me?
Thought he already worked at SPAR. That's what I have here. You know, he's starting a job there. He already works there.
Well, I've been working there, but I got fired, but
Now they're taking him back.
They'll take you back.
yeah,
He got fired over this case.
no,
Oh, okay.
And he's been reporting the pre-trial services.
19.
yes, ma'am.
Who's his mom?
Ah,
Hi, he lives with you?
Yes, ma'am.
Okay. 10,000 cash surety will continue. I'll remove the GPS tether.
thank you.
Thank you.
The no contact order, however, is still in place. Okay?
Okay.
Do you have any questions about your bond?
Okay.
Bond will continue. Good luck to you at circuit court.
Email that the agency, so, because they won't know.
For the bond?
Yeah.
I mean,
no,
for the
tether.
GPS tether?
Yeah,
The clerk's office takes care of that, so
they
they'll,
do, okay,
you'll let them know. Yeah.
okay, thank you very much, Your Honor.
Thank you. Have a good one. Have we seen Sebastian McClark? Seen Sebastian's attorney?
Haven't seen Mr. White. I know he responded, I think, oh, he didn't CC the court on it, but he responded to me saying that he wanted to leave it set for prelim. But he didn't state whether or not he and his client would be appearing today.
Okay, are we ready? I think that was that your last one.
Thanks. Double check it for it.
Lombardini, that's what it is.
Yeah, that's a AG case.
Fine, till 2:30 though.
I saw that.
Good afternoon. I see Tom Cranmer and then the AAG Stein Grand.
Yes, Your Honor. Good afternoon.
Good afternoon, Your Honor. Steen Grand, Assistant Attorney General.
Okay, this is the people of the state of Michigan versus Heather Lombardini, file number 24-00510 FY to date. And I do see Ms. Lombardini present via Zoom. Can you hear me, ma'am?
Yes.
Okay, great. Today's the date that was set for a probable cause conference. The matter is scheduled to proceed to preliminary examination next week, April 5th at 9:30 in person at the court. Count 1, uttering and publishing. Count 2, campaign finance, failing to file a statement of organization. Count 3, campaign finance, failing to file a statement of organization. And count 4, campaign finance ballot committee failure to file a campaign statement. Are we continuing to exam?
Your Honor, I've had the opportunity to communicate with Ms. Grand, and I know my colleague Jerry Gleason has had a discussion with her. The state has been kind enough to provide us with some discovery material in advance of the exam. And I think Ms. Grand would agree with me that it is voluminous. Again, I appreciate the fact that she's done that, but I can give you a sense that just with regard to emails that have been disclosed, my office technical people have indicated that there are approximately 70,000 emails. So we're still in the process of reviewing the discovery. And with the court's permission and Ms. Grand's permission, what we'd like to do is to adjourn this probable cause conference out perhaps into the May timeframe or so that we can properly review the discovery. And we'd be willing to waive the 21-day rule with regard to the exam itself.
Your Honor, on behalf of the people, I will admit that it is an enormous amount of discovery, and it is in excess of 70,000 emails alone. And I have no objection to extending the PCC out because it would be unfair to expect them to proceed with examination without the time to review all of those documents.
Okay. Okay, Ms. Lombardini, you understand that you have the right to have a preliminary examination in this matter within 21 days of the date that you're arraigned?
Yes.
And due to the voluminous discovery that's being turned over, do you freely and voluntarily waive the timeline so that your attorney can have time to review that discovery and prepare to formulate your defense?
Yes.
Okay. You said you, Mr. Cranmer, you wanted to have it adjourned until a PCC until May. Is that what you're asking for?
Yes, Your Honor. I think that would be an appropriate time frame to at least check back in with the court. And if that's again agreeable to Your Honor and Ms. Grand, that would be my suggestion. Perhaps during the week of May the 13th, if that would work for everyone's schedule.
I could do the 13th. I'm currently scheduled for a 2-week jury trial that is supposed to start the 14th. I think I've resolved the case, but the attorney is out of the state right now. So I can't commit to any date after the 14th until the week, well, until the 28th.
We can do May 16th or May 24th.
We can schedule it for the 16th, but with the caveat, I think it's going to be resolved. But if not, I may have to adjourn it. And just, I wanted to let the court know, and Mr. Cranmer and Ms. Lombardini.
Ms. Grand, would it be helpful to look to the 24th just because it's further out, and maybe even if you were in trial, you might be free by that time?
No, it's a very extensive trial, unfortunately. So why don't we set it for the 16th? And I'm hoping to know in the next 2 weeks. And I'll let you know if there's a problem, Mr. Cranmer, and then the
All right.
court.
That would be fun.
May 16th at 8:30 for another probable cause conference.
That would be just fine.
Give me a P date. June 6th at 8:30 works for a new exam date.
I'm sorry, what date?
June 6th.
Unfortunately, I'm going to be in the middle of a jury trial in Isabella County. June is, the end of May and all of June are pretty awful.
Are we,
You're asking for an exam date in July?
and we'd have no objection to that, Your Honor.
July 12th at 8:30.
July 12th works. Thank you.
Be fine, Your
No
Honor.
problem. No problem. Bond was set at 1,000 personal recognizance. That will continue as well as all the bond conditions. Any additional matters for the record?
Not on behalf of the defendant, Your Honor. Thank you.
None on behalf of the people. Thank you.
Excuse us.
Thank you. You're all set.
Righty. Thank you so much.
Thank you. On the record, in the matter of the people of the state of Michigan versus Nathan Joyner, file number 24-00106, 24-00536, 24-00679. Council appearance, please.
Yes, good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Joyner, who is seated in the courtroom to my right.
Okay, today was the date and the time that was scheduled for a preliminary examination. I believe on two of the files, and probable cause conference on the other, but I informed the parties that we will run all three today. And are we ready to proceed?
Freeman, do you need another few minutes with the client?
I'm sorry,
Do you need another few minutes with the client?
appreciate it.
If we could pause for a few minutes so we can speak to this client about the developments today.
Mr. Pfeiffer, if I may, Judge, Mr. Pfeiffer approached me a short time ago since lunch and made a suggestion that I thought was worthy of relating to my client, if I could. I don't think it's going to disrupt the procedures more than 3 minutes, 4 minutes.
Okay, so are you looking to step outside with your client, or where did you want to have this private conversation? Because there's a courtroom full of people behind you.
Yes, Judge. I have to defer to the court and to security folks.
Take him to the jury room.
I'll have my copies.
Back on the record on the matters of the state of Michigan versus Nathan Joyner. Are we ready to proceed now?
Yes, Your Honor.
Okay. Anything you need to place on the record or address before you call witnesses?
Yes, two things, Your Honor. First, the people are intending to add charges of witness interference, that being 10-year witness interference in each of these files for contacts that were made from the jail with the victim. And just as a point of order, the contacts did occur after the arraignment of the 24106 FY case. 4 arraignments in the other cases. However, there is case law that as long as the defendant has reason to know or believe that there is going to be criminal cases, that witness interference can still be charged in trying to stop or interfere with a witness's testimony therein. And I had made clear to the court, there were 2 other cases coming in front of the defense. So people's intention to add that in each file. And with the habitual fourth status, those will be life offenses. Now, I offered to waive these examinations and not add those charges and resolve this up with circuit court because I don't try and give global resolutions on multiple cases at the district court level. It is my understanding that after speaking with counsel, the defendant does not wish to do so and wants to proceed with the examination.
Mr. Freeman.
Your Honor, those are accurate statements offered by Mr. Pfeiffer with respect to the waiving or going forward with preliminary examination. Before we continue, could I please impose upon the court to see if there's a different device? This one seems not to be functioning.
Absolutely.
Thank you.
That's the only one we have. It's always not working sometimes, it does. Please.
Yep.
Say ABC 1, 2, 3.
ABC 1, 2, 3.
Thank you.
No problem.
Stand, because it has to be aligned with that thing, so if you stand over there, see if it works.
Okay. You haven't had any contact with it?
No, the information that you gave the sister is that the alleged victim recanted to the prosecutor verbally way before any of these charges was brought.
Can you hear us?
No, Your Honor. On the other hand, we don't want to delay. If I could just ask everyone to keep their voice up a little bit, I'm terribly sorry.
You don't know any reason to apologize. I have no problem speaking louder. Does this work for you?
Yes. that's
Okay,
fine.
sounds good. We'll make sure the witnesses are aware. Did you need a moment to talk to your client? I think he was trying to tell you something.
I think it's an issue of, he wants to speak to me, but I don't need to speak to him. So
It's up to you if you don't want to take a break, okay? You can call your witness.
Thank you, Your Honor. The people who call Officer Sean Rotunno. Thank you.
is that a word you learned in jail, infected?
No, I learned it a long time ago. I was judged. And you're being ineffective by saying that. You're not loyal to me. That's ineffective. It's my 14th Amendment. It's my right, read to the effective, and I be bring to the prosecutor.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat. Okay, there's a microphone in front of you, and we do need you to speak louder than your normal voice today, okay?
Okay.
Thank you. You can proceed, counsel.
Thank you. Good afternoon, Mr. Lieutenant.
Good afternoon.
Where are you currently employed?
City of Lansing through the police department.
And what is your role there?
Look, state your name first and last.
Oh, apologies.
No worries.
Sean Rotuno.
Please spell it.
SEANROTUNNO.
Thank you.
Now, you said that you're employed with the Lansing Police Department?
Yes,
What is your role there?
police officer,
And how long have you been employed by the Lansing Police Department?
3 years.
3 years. So were you employed in that capacity on January 14th, 2024?
Yes,
And on that day, did you make contact with a Nathan Joyner?
yes,
Did you arrest Mr. Joyner?
yes,
Do you see Mr. Joyner here?
yes.
Could you please identify where he's located? Maybe something about him that differentiates him from the people around him?
He is wearing the white undershirt, blue shirt over top of that, with dreadlocks.
Thank you. The record reflects that the officers identified the defendant.
Any objection to identification?
No objection. Thank you.
For the record, he has braids though, not dreadlocks. Is that accurate?
Yes,
Okay, thank you. Your identification is noted. You can proceed.
Thank you, Your Honor. Now, Officer Rotuno, when you arrested Nathan Joyner, did you discover that there was a PPO in place?
yes,
And was that PPO with protect party Sincere Dunbar?
yes,
That PPO in effect at the time?
yes.
Thank you. Now, why were you looking for Mr. Joyner that day?
So we were dispatched to a call at 900 Long Boulevard. When I arrived, I made contact with 2 people, one of which being Sincere Dunbar, who stated that Nathan Joyner was inside the home, and essentially they had been forced out, and that he was still there to the best of their knowledge.
Okay. And how did Ms. Dunbar seem when you were speaking with her?
Very erratic. So she was outside of the residence. She was not wearing shoes, not wearing a shirt, only her bra. And it was approximately 5 degrees out and windy. So the wind chill was likely underneath 0 degrees.
And did you confirm that was her residence?
Yes.
Thank you. Your Honor, at this time, I have no further questions for Officer Rotuno.
Cross-examination.
Thank you very much, Your Honor. Officer, you made reference to a personal protection order. I think shorthand is PPO.
Yes.
Was that something that you personally are aware of because you saw it or because someone told you about it?
It was in our lien system.
Okay. How long have you been with the Lansing Police Department?
3 years.
During that period of time, have you become acquainted with various forms that are used within the department?
Yes.
Your Honor, may I approach the witness?
You may.
That's the first one.
Yeah. Never mind what's written, but the form itself, is that something you've seen before?
proof of services, yes. This specific form,
No, just the form.
yeah, okay, yes.
All right, you've seen that form before. And as you view the form that I just put in front of you, I now ask you whether this is the PPO that you were referring to on your direct examination testimony.
Can I flip this over for the second part?
Sure. Yes. So this two-page personal protection order, in your judgment, is a companion, as it were, to the first form that I showed you that's titled Personal Protection Order Proof of Service. Is that right?
Yeah.
Can I see the 2 pages that were shown to him, the last two? Could I see those two?
Oh, yeah.
Thank you.
Didn't realize I may be wanting to offer these as exhibits this afternoon, and so I don't have clean copies. You'll notice the copies that I put in front of you has some yellow highlighting on it. That's
The people have no objection to that being admitted as exhibits with those highlights on it. If that's what the defense would like.
before I offer it, I want to ask the witness one more question. Thank you, counsel. On the proof of service document, the single page, about halfway down the page, it says copy of PPO provided to defendant. Do you see that?
I do.
And then there are two spaces after that. One says yes and one says no. Do you see that?
Yes.
And the one I'm looking at says no. Is that what you see?
That is what I see, yes.
Given your 3 years of tenure with the Lansing Police Department, an indication of no, would that tell you that whether the defendant had been provided a copy of the PPO?
Repeat that, I'm sorry.
In other words, it says yes and it says no.
Mhm.
If it's marked no, does that indicate to you that whoever it was, the respondent was not served a copy of the PPO?
Yes.
Okay, thank you. Your Honor, if with counsel's permission, then I would offer these as defense A and B.
Admitted without objection.
A is a one-page document, B is two. Thank you. We got a staple.
Yeah.
See those again?
Sure.
Thank you.
Officer, I believe you told us, let me just ask you though, you say you were dispatched to an address on Long Boulevard on the date we're talking about. Is that true?
Yes.
All right. And what was the nature of the call?
So originally it was an assault call, was the original call. On the way there, dispatch had advised that there had been a gunshot into the residence.
Okay. I assume you were not the only officer that was dispatched.
Correct.
All right. And did you find this defendant, Mr. Joyner, at that location?
Yes.
Okay. Thank you very much. Nothing further.
Redirect.
I'd like to approach the witness with defense exhibit A. Is there a line that says PPO served by?
Yes.
And what does it say after that?
Officer Mueller via telephone and D.O. Sterling
PPO Sterling.
is, he's a detention officer by the last name of Sterling who works at our Lansing Police Department lockup.
What does that indicate to you?
That would indicate to me that it was served via telephone by the detention officer Sterling, despite the fact that it says where it says no is marked and not yes.
So it was served, he just wasn't given a physical copy of it.
Objection and speculation.
Respond to the objection.
I don't believe it's speculation, given that defense was the one who started questioning him about his expertise in reading a proof of service form.
We opened the door for it by questioning him about how this would potentially be served. So I'm overruling the objection. You can respond.
Okay, can you repeat the question?
Yeah, absolutely. So to you, is this form indicating that he wasn't given a physical copy of it, but he received service over the phone about the PPO?
Yes, to me, this would indicate that it was served via telephone. The highlighted portion which says copy of PPO provided means that it would not have been, a physical copy would not have been given to him.
So he still would have been informed about the conditions of it.
It still would have been served, yes.
Objection as to the witness indicating that it would have been served. That's a legal term that the witness is not qualified to express an opinion.
I believe
Notified, that's fine.
I believe the defense had no problem with him using those types of terms when they were questioning him about this very topic.
Defense did use the term served when he questioned.
What's the court ruling?
I said you used the word or the term served when you were questioning him. So
Yes.
now you're saying that prosecution can't use the term served, you need to use notified?
No, Your Honor.
Because
I
the
believe-
term served calls for a legal conclusion? Is that
I
what you're saying?
believe I was reading right off the form. When I used the word, and it says served, yes, no.
Okay. I don't believe that whether or not his understanding of what services calls for a legal conclusion, so I'm gonna overrule the objection. You can move on.
Thank you, Your Honor. You were there when you discovered, wait, strike that for a moment. Mr. Jordan was found inside that residence?
Yes.
Was it easy to get inside that residence?
No.
What was your
Okay.
question?
Was it easy to get inside that residence? How come?
We tried going through the front door using a ram based on the circumstances that was the decision that was made. When we tried to use the ram on the front door, it appeared to have been barricaded. The door would open approximately, a small portion, then it would close immediately again without doing anything from the outside, indicating it was barricaded. So we went around to the back to the glass sliding door.
Thank you. Your Honor, at this time, I have no further questions for Officer Rotuno.
I think you could, someone published the exhibit.
Yes, Your Honor, I would seek to publish both exhibits to the court on
Thank
behalf
you.
of defense counsel.
You made the excuse, Officer Rotuno.
Are you signed for you, right?
Yeah.
Sign yours.
You can call your next witness.
Thank you. The people call Officer Cameron Peterson.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Thank you. You can have a seat. And I'm gonna ask that you keep your voice elevated. You can spell your name first and last.
Cameron Peterson, KAMERON, PETERSON.
Thank you. You can proceed, counsel.
Thank you. Mr. Peterson, where are you currently employed?
Lansing Police Department,
And what's your role there?
patrol officer.
How long have you been employed with them?
Approximately employed since January of 2022.
So a little over a year at this point. Were you working in that capacity as an officer on January 14th, 2024?
Yes, I was.
And on that day, did you go out to 900 Long Boulevard?
Yes, I did.
Now, is that in Lansing?
Yes, it is.
Is that in Ingham County?
Yes.
And on that day, did you make contact with a Sincere Dunbar and an Alicia Ronkel?
Yes, I did.
What were their demeanors like when you were talking with them?
I'm sorry.
What were their demeanors like when you were talking with them? And please do speak at a higher than normal volume today.
Yes. When I originally arrived on scene, the two females appeared to be extremely traumatized. Both females were only in bras. They only had, I can recall, neither of them had shoes on. It was snowy, icy, and approximately 6 degrees at that time.
Now, did you speak with both of these women?
Yes, I did.
They said that they appeared traumatized. Did they talk to you about what had caused them to be like that?
Yes, they did.
So, with Sincere Dunbar, did she tell you who had, like, did she tell you that an assault had taken place?
Yes, she did.
Okay, did she tell you who had performed that assault?
Yes, she did.
Okay, and what was that name?
Objection, Your Honor, hearsay.
You want to respond to the objection?
MCL 76827C, as well as excited utterances. He's literally being told about the startling incident while they're still under the effect of it.
Objections overruled.
So what was the name that she gave?
Nathan Joyner Jr.
And did she say how she knew Mr. Joyner?
Yes, they had been dating for approximately 1 year.
Okay. Did she say anything about a personal protection order?
Yes, she did.
And what did she say about that?
That she
Objection as to an excited utterance about a protection order. This seems a bit far.
Okay, but what is the objection? That it seems a bit far, or you're saying?
It sounds like the conversation was moving along between the officer and this witness, and excited utterance to me smacks of an emotional statement, really, at the moment. And talking about a PPO seems to go a bit beyond.
Excited utterance is what you're saying? I
Yes,
agree
sir.
that it would go beyond an excited utterance. You're laying the foundation for 27C?
Yes, sir. I can come back to this part.
Okay. Well, he's gonna withdraw his question at this point, then.
Yes. Now, did she say how recently this assault took place?
Yes,
And can you give us a ballpark for that?
right before they called 911.
Okay, so fairly recently.
Yes,
And was there anything that was personally observed that seemed to match up with what she told you would happen?
yes.
And what was that?
For Dunbar,
Yes.
I may have mixed up the two females. Can I take that one back?
Absolutely. Here, let me ask another question. Did they tell you that there had been a shot fired?
When the witness is on the stand.
Yes,
And did you see a bullet hole? Or was it
I
a
did
bullet hole?
not observe a bullet hole.
Did other officers discover a bullet hole?
Yes, they did.
Thank you. Further, did Ms. Dunbar tell you that Nathan Joyner was inside that residence?
Yes, she did.
And was he discovered inside that residence?
Yes, he was.
Thank you. Your Honor, at this time, I believe that there's been a sufficient factual basis laid to proceed under MCL 768.27C.
I'm sorry, Counsel.
I apologize. I really am. At this time, I believe there has been a sufficient factual basis to proceed under MCL 768.27C.
Any objection?
Your Honor, I had to challenge the foundation. I believe the statute requires some demonstration that the witness is unavailable.
That's not true.
Looking at the statute here, I'm trying to see what portion of the statute requires the witness to be unavailable.
Further, I will say the Supreme Court has even said unavailability is not required under People v. Only. I would say the Supreme Court affirmed this Court of Appeals saying unavailability is not required specifically for MCL 768.27C.
That may be the case I'm thinking of, and I, with all due respect to my learned colleague, walked away with a different opinion of that, of the Court of Appeals, that was a condition preceding.
Your objection is noted, but it's overruled.
Thank you.
You can continue.
Did Ms. Dunbar tell you about a personal protection order?
Yes, she did.
And what did she tell you about it?
That she has a personal protection order against Nathan Joyner Jr. due to the past history of domestic violence issues between the two.
And that was the person she said was inside her house.
Yes.
Great. Now, what did Ms. Dunbar tell you happened this night?
She told me that she was with her friend, Ron Call, and her cousin Jackson. They had been together bar hopping between bars. At that time, they drove their car to the Glenburn address noted in my report to drop off Jackson. Dunbar then stated that Mr. Joyner, I'd like to take it back. During the ride to Glenburn, Jackson had a phone call with Mr. Joyner indicating that they were going to be going to the Glenburn address.
Objection, Your Honor. Is this witness referring to a second female, a third person communicating this to him? Or is this all from Ms. Dunbar? And if it is, then it's hearsay within hearsay.
My understanding is that he spoke with the victim, but he did say he needed to, he's gotten some parties
that's fair.
confused. Can you clarify that for the record?
Absolutely. Now, we're talking about what Ms. Dunbar told you, correct?
Yes, correct.
And she was telling you about the incidents that what led up to the assault?
Correct.
Okay.
Your objection was whether or not Ms. Dunbar is the one who heard the phone call, or was someone else telling her that there was a phone call?
Whether it was Ms. Dunbar relating what she herself had seen or heard to the officer, that's fine. Or I may have misunderstood, but I thought the officer was relating something that he had heard from another occupant of that vehicle, someone other than Ms. Dunbar.
Okay, my understanding is that this is coming from Ms. Dunbar, so with that understanding, the objection's overruled.
Thank you, Your Honor.
Okay, and I think you stopped up,
Yes.
they were riding to Glenburn and Jackson was on the phone with, was it Joyner?
Correct, Your Honor.
So what did Ms. Dunbar tell you happened next?
When they arrived to the Glenburn address, Joyner also drove to the Glenburn address in a white Dodge Charger. At that time, he got stuck in the snow. Dunbar then stated Joyner walked to her driver's side window and made contact with her at the window.
And what did she tell you happened at the window?
He was asking for a ride, and at that time, he became verbally upset.
Okay. And did they give him a ride?
They did not give him a ride.
So what did she say happened after they wouldn't give him a ride?
That Mr. Joyner went to the back door, opened it up, and pulled out Miss Roncall by her hair. And at that time, Miss Jackson got out of the car and went inside of her Glenburn address, grabbed a firearm, and came back outside of the Glenburn address.
And so what did Ms. Dunbar tell you happened with this firearm?
Due to the fear of the assault, Miss Jackson fired two shots into the air.
As warning shots?
As warning shots.
Now, after this happened, did they go over to the 900 Long Boulevard?
Yes, they did. They left in fear and went back to 900 Long Boulevard.
And then at some point, did Nathan Joyner arrive, according to Ms. Dunbar, at the 900 Long Boulevard?
Correct.
And what did she tell you about that?
He stated that her and Ron Cowell went back to the address and were inside the address at 900 Long Boulevard. At that time, Miss Dunbar stated that Miss Roncal saw a blue Saturn view driven by Miss Jackson and Mr. Joyner arrive to the address.
And so, did Ms. Dunbar tell you that she saw Mr. Joyner there outside?
Correct.
So, what happened after, what did Ms. Dunbar tell you happened after she saw Nathan Joyner outside of her home?
Her and Miss Roncal went downstairs, and Miss Roncal barricaded her body against the front entryway door.
And what did Ms. Dunbar tell you she observed next?
She observed while Miss Roncal was barricading herself against the door, a bullet came through the entryway door. And at that time, Miss Roncal, due to the fear, loosened up her body barricading against the door. And the door came open, and Mr. Joyner then grabbed Miss Roncal by her hair and dragged her out of the 900 Long Boulevard residence.
Now, Ms. Dunbar was with Ms. Roncal inside the residence, correct?
Correct.
When the shot was fired into the residence.
Correct.
Was it from the direction that they had seen Mr. Joyner?
Correct.
So, Mr. Joyner was pulled Roncal out by her hair. What does Ms. Dunbar tell you happens next? Does she tell you how she ends up outside?
Yes, she exited the residence as well. And after Mr. Joyner released Miss Roncal, both of the two females went back to Miss Dunbar's car in order to plug their phone in to call 911.
Is it this time that Mr. Joyner goes inside the residence?
Correct.
He also spoke with Ms. Roncal, correct?
Correct.
And what was her demeanor like when you spoke to her? I know you said that she seemed traumatized. Was she crying at all?
Yes, she was hysterically crying. She appeared to be a mess. Her hair was a mess, and her emotions were all over the place again.
This is Miss Dunbar we're talking about?
Ms. Roncal.
Miss Roncal, okay.
So what did Ms. Roncal tell you happened? Did it seem to match what Ms. Dunbar was saying?
Yes. She stated that while talking to her too, she was very concerned about her appearance.
I beg your pardon, Your Honor. Now I don't know where the officer is getting this testimony from, who is speaking. Are we still talking about statements Ms. Dunbar told the officer?
No, we're talking about what Ms. Roncal has told the officer.
And I object.
Cited utterance. She is actively hysterically crying while she tells this officer about what stressful incident has made her actively hysterically crying.
They left Long Boulevard, they went to another address, and now they're back,
No,
and it's an excited utterance.
This is shortly after, I think the testimony was that there was a bullet that went through the door. And then apparently, allegedly, Miss Roncal was dragged outside by her hair. At the same residence.
And is it the court's understanding that this witness is testifying as to what this woman told him at that moment?
Well, so far, the testimony hasn't even got into what she has said, just that she was hysterical, or she was a hysterical mess is what he said. She was crying, concerned about her appearance, and that's when you objected. So I'm assuming we were going to get into
Yeah,
what
primarily,
the person was going to state.
I lost track of who we're talking about.
You were talking about Ms. Roncal. I asked that question too. We're talking about Ms. Roncal. This witness has not yet said what Ms. Roncal said, but I think that was coming next right before you objected. And he's indicating that it's an excited utterance. You wanted to respond to his response.
Well, I suppose it has something to do with what the witness said. I'll withdraw my objection for the moment and listen, and I may have to raise it again. Thank you.
Thank you. You can continue, counsel.
Does Ms. Ronkel tell you that she was dragged out by her hair?
Yes, she did.
Did Ms. Ronkel tell you that she was shot at?
Yes, she did.
Did she say that she was afraid for her life?
Yes, she did.
Did she tell you who she believed shot at her?
Yes, she did.
And who did she believe shot at her?
Nathan Joyner.
Objection, speculation.
It's
You said who shot at her, telling who shot at her was speculation, you're saying?
Yes, my understanding is that the door was.
You're saying that who she believed was speculation. She's not testifying. He's telling what this person said, who this person said shot at him. What he's saying is not speculation. Whether or not Ms. Ronco was speculating is not, she's not on the stand.
Thank you, Your Honor.
Objections overruled.
Did she tell you why she believed Nathan Joyner shot at her?
Yes, she did.
And what did she tell you?
In previous contact with him, that he had threatened to kill her in the past.
Thank you.
Here. Yes.
Now, did you observe any injury to Ms. Ronkel?
Not any actual physical injury that I could observe.
Did any of her skin seem red?
Yes, I apologize about that. Upon first contact with her, her skin did appear red.
And then, so upon first contact, does that imply that it faded over the course of your interaction?
Correct.
Did she say if she was feeling any pain?
Yes, she did.
And what did she tell you about that?
I recall her feeling pain in the head. That's what all I can recall.
Okay. Is it difficult to remember exactly what she told you about the pain?
Yes, it is. If I could refresh my memory.
Do you think looking copy report will help refresh your recollection?
This is.
Your Honor, I can approach the officer with an unmarked copy of the report.
You may.
Now, officer, I don't want you to read aloud from this. What I'd like you to do is read it to yourself silently. Let me know when you feel it's either sufficiently refreshed your recollection or it's just not going to be possible to do so. I will come take it back for you and I'll ask you the question again. Sound good?
Sounds good.
Okay.
Number one, I can't hear you, so I can't understand you.
Objective that he's coaching you right now in front of your eyes. And you're allowing it.
Sir, did you want to let your attorney be the attorney, or did you want to represent yourself today?
Your Honor, no disrespect to the courts, but honestly, no disrespect to Mr. Freeman, I would surely love to represent myself in this matter.
Because you keep disrupting him from being able to hear what's going on. And he's already indicated that he has a hearing impairment. So what do you think that's doing? Excuse me?
I'm sorry, it seems to me that he's incompetent to represent me, and if he can't hear, how can he?
You think that someone not having a hearing impairment makes them incompetent to represent you?
He can't hear
And you
facts.
believe you're more competent to represent yourself and you're facing life?
I don't believe I'm more capable of representing
Oh,
myself.
are you legally trained?
No, ma'am.
Okay.
I
You know
just
the rules about evidence?
I know some, but not
Which
all.
rules of evidence do you know?
Offhand, none right now.
Exactly. Do you think that he probably knows the rules of evidence?
Yes, ma'am.
Yeah, so let him do his job. He can't do it though if you keep yelling in his ear while he's trying to hear the witness, and we're already talking loud so he can hear us.
Not yelling in his ear.
He doesn't need you to tell him when to say objection. How many years of practice do you have?
31, Your Honor.
How old are you?
36, Your Honor.
I think he knows how to put an objection on the record, okay? If you have something that you want him to address, you have a piece of paper right there, you write it down.
Your Honor, with all due respect, why should I have to write something down that's already written down in a police report? I'm trying to just show him to read it. If he's not reading what I'm trying to show him, what's good?
Write it down so that you're not distracting him from paying attention because he's trying to defend you while you're distracting him. You can write it down and then he can look at it when it's appropriate. You yelling at him is not going to help you. Okay? Thank you.
I believe the officer motioned to me that he had had enough time to look this over if I could retrieve it from the officer.
You may.
Now, officer, was that able to sufficiently refresh your recollection?
Yes, it was.
So what did Ms. Ronkel tell you about the pain she was feeling?
But she had neck pain, head pain, pain in her hip, and her face.
Okay. Your Honor, at this time, people have no further questions for this witness.
Cross-examination.
Thank you very much, Your Honor. Officer, I believe we were talking, or you were talking to counsel about a date, January 14th of 2024. Does that sound about right?
Correct.
Personally, did you have any involvement in any other investigations regarding that same address on Long Boulevard, perhaps on different dates?
I did not.
This is the only time that you were involved with either Ms. Dunbar or Ms. Ron Cowell or Mr. Joyner?
Correct.
Thank you. Did you ever enter that address, apartment or townhouse, I guess they are, 826?
I did not.
Did you attempt to?
I did not.
Did you want to?
I did
you speak to any other officer who did?
I did not.
During your portion of this investigation, did you come to discover whether any of the closets held men's clothing?
I did not.
During your part of this investigation, did you come to an understanding as to whether there was more than one toothbrush in the bathroom?
I did not.
Your part of this investigation include discovery of who was paying the rent at that location every month?
I did not.
Any indication that Mr. Joyner was not a resident of that location? That all came from Ms. Dunbar, is that fair?
Correct.
She said it. And you and other officers acted accordingly, is that fair?
Correct.
Or do you have personal knowledge as to whether any other police officer on the scene that night asked Ms. Dunbar if they could take a look inside her apartment?
I asked for that.
As to whether you could look in her apartment?
Yeah, I obtained a consent to search form that she signed.
And just so we're on the same page, I'm talking about 900 Long Boulevard, apartment 826. Is that what you're talking about?
Correct.
And she allowed you to, what did she allow you to do?
If I can recall, it was to search the residence for Nathan Joyner and anything related to a assault or any crime that we faced that day.
And was one of the crimes you were investigating home invasion?
Correct.
Did you make any attempt to determination as to whether Mr. Joyner was a resident at that location?
Not after speaking with the victim, no.
You had her word and that was as far as it went. Is that fair?
Correct.
Okay. When you first arrived, did you tell us that Ms. Dunbar and Ms. Ron Cal were both outside?
Of the residents,
Yeah, 900 Long Boulevard.
they were outside at the end of the incident.
I'm not trying to trick you up.
No,
Okay, you pull in. Are they in or are they out?
they were outside.
Okay. If I understood your testimony, it would be fair to say that both women were scantily clad,
Correct.
wearing brasiers only?
They had shorts on as well. I cannot fully recall their clothes, but not only blues.
Okay, thank you. And of course, it was February and it was cold, right?
It was January, correct.
Yeah, I'm sorry, January, you're right. As a Michigan resident, little out of the ordinary to be out in shorts on a cold January night. Is that fair to say?
Correct.
How long have you been a policeman?
I've been a patrol officer for approximately 10 months.
During that period of time, have you had occasion to run into people that you determined to be intoxicated?
Correct.
Did you develop an opinion after your speaking and observing Ms. Dunbar as to her sobriety or lack of it?
Could you rephrase that question for me one more time?
After you were speaking to Ms. Dunbar and you had a physical, you saw her, you were observing her, did you develop an opinion as to whether, I'll start here, she had been consuming alcoholic beverages?
I did not form an opinion, no.
Did you receive information that Ms. Dunbar and Ms. Roncal had been, I think the phrase was bar hopping?
Correct.
Did you smell the odor of intoxicants on Ms. Dunbar's breath?
Not on Miss Dunbar.
Okay. Did you speak to Mr. Joyner on the January 14th, 2024?
I did not.
Were you in the presence of any police officer who did?
I was not on that day.
Within earshot, you know what I mean? Okay. Do you know whether Mr. Joyner had a key to apartment 826 on his person on that night?
I was not aware.
For the record, I believe opposing counsel means apartment 286.
I'm sorry.
I believe opposing counsel means 286, not 826. For the
Oh, did I
apartment.
misspeak? Thank you very much.
286.
Your Honor, if I may be forgiven for just a half a moment, if I have been speaking to this witness about apartment 826, it has just been brought to my attention. That's a typographical error. We're really talking about apartment 286. Thank you.
Thank you.
Officer, did your portion of this investigation conclude on that same day, January 14th?
Correct.
If you know, and if you don't, you don't, but do you know whether any other officer or perhaps detectives did any additional investigation on this case after January 14th?
I'm not aware of any follow-up.
All right, thank you. Thank you, Your Honor.
You redirect.
Incredibly briefly. Defense counsel described your learning as brassieres. Let me put this in as plain of a language question as I can. Did these women appear to be outside in the cold in their underwear, or women who appeared to be looking like they were trying to strip for somebody outside?
They look to appear to be out in their underwear.
Thank you. No further questions, Your Honor.
Thank you. Ms. Officer, be excused.
You may, Your Honor.
Thank you, may be excused.
Thank you.
You can call your next witness.
The people called Detective Sarah Wilson.
You come up. I don't know if you wanted to put your bag down over there. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, sir.
Thank you, officer. You can have a seat. And if I can ask you to use your louder voice inside today, one of the attorneys has a hearing impairment, okay?
Certainly, Your Honor.
State your first and last name, spell both.
Sarah Wilson, SARAHWILLSON.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Ms. Wilson.
Good afternoon.
Where are you currently employed?
With the City of Lansing Police Department.
And what is your role there?
I'm a detective.
And were you assigned to do some investigation on the cases involving Nathan Joyner?
Yes, I was.
Now, Detective Wilson, do you have access to the jail communication systems in the Ingham County Correctional?
Yes, I do.
I'd like to approach the witness who what's marked as People's Proposed Exhibit 2 and 3.
Okay.
Now, Officer Wilson, I previously showed you these two exhibits before today's hearing. Do you recognize them?
Yes, I do.
Now, are these screen grabs from the jail's communication system?
Thank you.
Yes.
Now, is one of these labeled with the name Sincere Dunbar?
Yes, it is.
And what is the other one?
Gabrielle Douglas.
Now, is there something to indicate that these are actually both Sincere Dunbar?
Yes, there is.
And what is that?
Well, Sincere's middle name is actually Gabrielle. The Gabrielle account also has the address 717 West Kalamazoo listed for it, which in the Lansing Police Department report writing system is a previous address for Sincere Dunbar. Additionally, the dates of birth are very close. Sincere's date of birth is 11/25 of 99, and Gabrielle's listed as 11/24 of 99. They also have the usernames are similar. Sincere's account is Cindy Pop 11/25, while Gabrielle's is Cindy Bun 99, with Cindy being spelled the same way, SINNEY in both accounts.
Thank you. Here at this time, people would seek to admit to proposed exhibits 2 and 3 into evidence.
Any objection?
Just a brief one there, if I may.
Please.
Is it detective?
Yes, it is.
when you are looking at those two proposed exhibits, are you able to tell the identity of the creator?
The creator of the account, well, in theory, the user information is what they provided as being the creator.
And so it may or may not truly identify the individual. It identifies whatever the creator of the account inputted.
Yes,
Is it fair?
I would say that's fair, yes.
All right, thank you, Judge. No objection.
Timothy, you're admitted.
Thank you, Your Honor. I'd like to approach the witness, what's marked People's Pose Exhibit 1. Now, Detective, I also showed you People's Pose Exhibit 1 before today's hearing. Is that correct?
That is correct.
And what is People's Pose Exhibit 1?
It appears to be messages within the Young County Jail messaging system.
And even before today's hearing, you're able to confirm that these are messages that are currently live in the Ingham County Jail system?
Yes.
Thank you. Your Honor, at this time, people seek to admit People's Pose Exhibit 1 into evidence.
Yes, sir.
Thank you very much, Your Honor. Counsel has provided the defense with copies. I've reviewed them. I understand and I have no objection. Thank you.
People 1 is admitted.
Thank you. Now, Detective Wilson, there are messages in here from inmates named something other than Nathan Joyner, correct?
That is correct.
There are messages from Nathan Joyner's account, but also from other inmate messages.
Yes.
Is it common to see inmates use other inmate accounts to communicate?
Yes, I have seen that before.
And from looking at these messages, does it appear to be the same person communicating between both of them?
Yes, it does.
And what is that based on?
Based on the one account here, Davin Carter talked specifically about trying to get paperwork to Judge Simmons' court. And they talk about the relationship and how they need to get a PPO rescinded as well, since your Dunbar does have or at least at the time, did have a PPO. I'm not sure if he still does, against Mr. Joyner.
Okay. Now, at some point, do they also talk about the need for an affidavit?
Yes.
And what is the affidavit in regards to?
I believe that was in regards to telling the court that that she was intoxicated or something, and that basically what she said wasn't accurate about what had happened.
I'm not really objecting. I'm begging the court's pardon and counsel's. If the witness could be perhaps a little more clear as to she.
Okay, I agree.
By she, do you mean the person that they are communicating with outside the jail?
Yes.
Okay. Now, if I could retrieve this just one moment. Now, I want to draw your attention to page 3 of 9 in a message that is titled R.E. Lion Ass. Who is the sender of that message?
It shows that it's from an inmate named Davin Carter.
And who is it being sent to?
It shows Gabrielle Douglas.
Now, Detective Wilson, could you please read that message aloud for the court?
Would you like the entirety of the message?
The entirety of that message.
Okay, you write, I love you. And if you would have listened to me, you wouldn't have had to come out that money for the car. If you hadn't lied on me, I wouldn't be in here for you to have to send me shit. You're not incriminating yourself. They can't do shit to you for being drunk and not remembering what happened. I know the law, but don't get it confused. I'm very grateful for everything. But I do feel like if I can love you enough to forgive you for putting these serious ass charges on me, jeopardizing my freedom, then you should love me enough to forgive me and answer my MFKN calls because of what you've seen in my PHN, I believe that's phone. Like, really, yes, you are untitled to be hurt, but now it is not the time to be cutting off my communication to you, Bunny. Communication is key. And secondly, ain't shit broke about me. I'm taking care of business from in here just for you to shit on me. But I ain't gonna lie, hearing you talk like that shit like turned me on. FR, for real. LOL. It ain't do shit but make this thing hard as hell. And when I get home, I'm gonna knock that off the frame. Don't play with me, Bunny. I need you. I love and miss you. I've been punished enough. The sooner we can get past this, the sooner I can get back to the money I told you. You don't stress about no money. Get me TF. Generally, that I've heard that be the fuck out of here. Keep my phone on at all times and answer my calls. Listen, for real. I hope this message made you smile because I've been missing your little ass head. Or little head ass, my apologies. Listen, life is short sometimes. God puts you through certain things in life to wake you up, and I need this. It motivated me. Great is a man who has ambition, and attractive is a man who is educated. I know sometimes I be on your ass, but I see you. Like, listen, I see you.
Thank you.
Look at that. Judge, you become fearful.
Yes, counsel.
I respectfully urge the court to consider a motion for me to please be seated in the jury box or the defendant removed to a different location.
That's up to you. I can put you in the jury box, or I can put him in the jury box.
I'm sorry?
Do you want me to put you in the jury box or him in the jury box?
Well, it'd be better if he was.
The motion is granted.
Thanks to the court. And just for the record, he can still see and hear the witness, of course.
That's another problem. That's it.
Proceed, counsel.
Thank you.
Sorry for the interruption.
It's okay. Now, this message, the woman is referred to as Bunny. Is that right?
That's correct.
Are there messages from Nathan Joyner's account that also refers to them as Bunny?
I believe so, yes.
You go to page 8 of 9, I believe right at the top.
Yes, I see it lists the sender on page 7 as Nathan Joyner, and at the top of page 8, he refers to her as Bunny.
Thank you. Okay. I wanted you to go to the bottom of page 6 under a message called Please No. That's no with a K. K-N-O-W. And who is that one from?
Nathan Joyner,
And who is that to?
Gabrielle Douglas.
Could you please read that one for the court?
I want her to know the importance of the affidavit is because they can try to use the fact that we've been having contact with each other against me and keep me in here alone, no matter if she don't come to court. That cannot do anything to her for admitting she was drunk and that I do live at my house. That's so important. That affidavit is what's going to get me out of jail by my next court date. The affidavit is key to my freedom. I can't, CNT possibly can't express it enough. I cannot have any more contact with Sincere from here. I can visit Michelle if she make a profile on my phone, PHN,
That's the only way. It all comes down to how bad you want me out of here. The affidavit is a vital key to my freedom and will keep trying to drag me month after month. Please listen to me and trust that I would not ever risk getting her in trouble. I know what I'm talking about.
The next message down, do they talk about Michelle's account as well?
Yes, they do.
Does it appear that they're actually trying to get in contact with Michelle? Or just they want to use her account?
It appears they want to use her account.
Okay, to not be seen.
I'm sorry?
To not be seen. And the last message I would like you to read for the court is on page 1, and it's titled Love. Please read that for the court.
Good morning. I love you, Bunny. I know that things are complicated for you, but I want you to know that I'm so proud of you for holding things down and taking care of business through it all. You're so strong and smart. Baby, I miss you so much. I'm sorry I've been a bug to you, but this stuff is serious. My life is really in these people's hands right now. I need you, baby. Without you, they are gonna hang me. I know that I've been asking you to do a lot, but I need you to do this one, Bunny. Forget about a affidavit, never mind that. I really need you to write that letter to the judge to let her know that I didn't do anything wrong and that you was drunk and that we are together and that I do live in our house and that you really didn't know the seriousness of calling the police on me. Please get that letter to Judge Simmons' secretary, not the prosecutor. You don't have to speak to them at all, but you can call them and tell them that you made up what you said out of being drunk and they can't CMT and will not do anything to you. Take the letter directly to the judge's clerk or secretary. That letter is very vital. It's what's going to save my life. I also really need you to get that PPO court date rescheduled immediately. Those are the two most important things you have to do for me to come home. I'm begging you to not put this off, baby. I need you. Naomi needs me. Dude Man needs me. And I know you need me too. Do not let the system rob me of my freedom. Do not let the devil tear us apart. I love you very much, and I have faith in you. I know you can do this. I love you. I love you. I love you.
Thank you, Detective Wilson. I'd like the court to take judicial notice the fact that in one of our earlier hearings, I brought to the court's attention the fact that he was speaking with Sincere Dunbar, the victim.
Noted.
Thank you.
February 1st, according to my notes.
Thank you. Detective, when are these messages to Gabrielle Douglas start?
The first one I see says February 2nd.
Last day. And in fact, on People's Exhibit 2, on the right-hand side of it, does it say what day that account was created?
It says February 2nd, 2024.
Thank you. I have no further questions for this witness, Your Honor.
Prosecutor.
Thank you very much, Your Honor. Detective, I'm going to refer to, for just a couple of questions to, I just forgot the number. The messages that were just referred to and that you read aloud, okay?
I understand.
My copy of that indicates various dates. There seems to be a date affixed to each of those entries. Is that what you see as well?
Yes, I see a date for each separate communication, yes.
And was alluded to at direct examination that perhaps some of the names are fictitious. Can you tell me as to whether the dates where it says a date sent, is that accurate on these entries?
I'm not sure I know enough about the jail system. I don't know that there is a way to manipulate that. I would assume that is automatically created by the jail system, but I can't speak exactly how that date's generated.
Fair enough. Fair enough. Thank you. Did these tend to proceed in a chronological order if we refer to the dates sent?
They do appear to proceed in a chronological order, yes.
All right, thank you. There are names associated with some of these. The one seems to be most predominant is David Carter. Are you able to tell us today whether the jail did house an individual by the name of David Carter in February of 2024?
I do not know for certain if the jail housed someone by that name.
That's fine. Note today as to whether the jail housed an inmate by the name of Gabriel Douglas on or about February of this year.
I believe the Gabriel Douglas account is actually what's called a public user account. And I wouldn't expect that to be an inmate. I would expect that to be someone outside the jail.
I see, because of its relationship in each of these messages.
Yes, yes, and the David Carter, like after his name, it says inmate, includes an inmate ID, while Gabriel Douglas says public and includes their user ID.
Are inmates able to use this technology to communicate with each other in the jail?
I do not know. I haven't seen any messages personally that indicate that they can, but I don't know 100% that they cannot.
No, you can just say you don't know. Thank you very much. Your name is indicated on the original complaint with respect to docket 24-00536FY. It's from something of January 6th of 2024. You are Detective Sarah Wilson, WILLSON, is that right?
That is correct.
Are you here today to testify that this defendant, Nathan Joyner, is responsible for sending any of these messages other than the ones that are clearly indicated with his name?
I would say from the context of the messages, it appears that he is also sending the ones under the name Gavin Carter.
Well, whether you have a rational basis, my question really was, is that you're here to indicate that you believe that he sent some of these messages under a fictitious name. Is that about right?
Objection, Your Honor, asked and answered.
I don't think she answered it.
To the extent that you're asking, was she here to testify if the defendant was using Gavin Carter's account? Is that what you're saying? Or
no?
What is your question?
My intent was to ask the witness whether her understanding of her participation in this, in testifying today, is to indicate that this defendant sent some of these messages under a fictitious name, if that's what she suspects, or that's what she believes, that's what she's trying to convey.
Okay, I'll allow to answer the question. You can answer.
It could just be answered yes or no.
In part at least, yes.
Okay, thank you very much. You had any formal training with this? It's not a device, but this, what would you call that? A software package that this system is used by the jail?
I believe we did like an online training quite some time ago. It has been a while.
That's all I have for today, Your Honor. Thank you.
Any redirect?
No.
Your Honor, may I speak, please?
You may.
Put on the record that before any message was ever sent out, before any court date appearance, my lawyer brought to my attention that my sister told him that Ms. Dunbar contacted the prosecutor verbally and in person and recanted her statement way before any phone conversation or message was ever sent out. And they're leaving that off the record.
That's up to the prosecutor if they want to leave it off the record.
Okay, I was just putting it on the record.
Okay, thank you. It's noted.
For the record, I've spoken very briefly with the victim when she was here for the first preliminary examination day. I'll check my records and see if somebody else spoke to her while at our office, but I don't have anything else other than that.
May Detective be excused from the stand at this time?
You may, Your Honor.
And I'm just for my clarification, I only have testimony on file number 679 so far, correct?
Your Honor, this detective's testimony would apply to all three cases, as the witness interference goes to all three cases that involve Sincere Dunbar.
I recognize that, but I thought we were doing preliminary examinations on all three.
Correct, Your Honor.
So, and is she being called back to testify?
First of all, I believe that we were holding all three of these.
Correct.
No, I mean, right now.
Agreed.
Right now. While she's speaking to all three cases, is what I mean.
I understand that as it relates to witness interference, but the facts of the underlying incidents.
Correct, sorry.
Is she coming back to testify to that? Because right
No,
now, I only have testimony and venue on one.
Correct, Your Honor.
I just wanted to make sure, okay.
No.
Just because he asked about whether or not he noticed her name on the other file. So is she excused just from the stand or from the building?
From the building.
Okay, thank you. You may be excused, Detective.
Apologies, I understand now.
Your Honor, may I speak again?
You absolutely can. You understand your right to remain silent, but you want to waive it, correct?
I don't want to waive my full rights.
No, just at this time for you to speak.
Yes, I just want to put something else on the record.
You
right
can.
now.
Did you want, give me just a moment. You need to publish those.
I was arraigned for charges. I believe it was March 1st. I was arraigned for new charges for one of those cases, files.
I see you were arraigned on March 4th at file number 24-00536. And then it looks like you were arraigned on March 14th
Yes, Your Honor.
on the 24-00679.
Yes, Your Honor. I just want to put that on the record that those messages that he's allowing her to testify for and phone calls or whatnot, those were all made prior to me being arraigned.
On those two files?
Those 2 files.
Oh, okay, thank you.
Yes, ma'am.
One, I would seek to publish these to the court.
You can.
Exhibits 1, 2, and 3. Thank you. I'm gonna put the paperclip back on to 1. Second, I don't know if you want me to respond to that or not, but
You feel free to respond. It's up to you.
yeah. It doesn't matter if he was arraigned. That would only go to it being a bond violation. There's case law saying as long as you know or reasonably know that a criminal hearing is going to be happening in the future against you, then witness interference can still apply. And I would also note that on that same day, I made the court aware that he was contacting Sincere Dunbar. I made the court very much aware of the fact of the 2 new cases that were coming with Sincere Dunbar. So he had knowledge of them.
Well, just so the court is clear, I recognize his statement that he was arraigned on March 1st, but it really was March 4th on one file, March 14th on the other. But that totally disregards file number 24-00106, which he was arraigned in January, and there was a no contact order. So that's both bond violation and new charges for witness interference.
Yes.
That you would be facing because you were arraigned on one file with that individual named as a protected party. Do you understand that?
Yeah.
Okay. You can call your next witness.
And this was the moment of panic that I had before. Before we started, I said that there were two things I needed to address. I got through the one, and then we dealt with the hearing issue. And then I completely forgot to address issue number 2, and I do sincerely apologize for that. The other officer that I would be having testify is Seth Osentowski. Seth Osentowski is a night shift officer. I have called him. I sent emails weeks ago. He knew about today's hearing. He was subpoenaed. He is not here. I had my other officers call and text, did not receive any response because most likely that man is asleep. Again, I was fully intending to handle everything today. That's why I tried to set everything for today. At the very least, the people are done in file 24106 FY, and Officer Wilson testified to witness interference charges for the other 2 cases as well, because it applies to all 3. At this time, I would be seeking continuance in order to get Seth Osentowski's testimony in regards to file 24-536 FY and 24-679 FY. Again, I apologize. I think this court knows if I know an officer's in here, I try and put that up front bluntly.
Your Honor, just work.
You may.
To my knowledge, I have a 6th Amendment right. And there's a confrontational clause. And it applies if it says the circuit court held that the exception could not apply because the statements of the complainant are testimonial.
I'm not following what this is referencing though.
His witnesses are police officers.
Correct.
And they're giving statements from.
Talking about the hearsay?
Victims. Yes.
Okay.
And
gotcha.
And the statements that they're giving are testimonial. And they're violating my confrontation clause, which is my 6th Amendment, by giving those statements with disregard that he's disregarding Mr. Pfeiffer. When I say he's disregarding the fact that they never declared her unavailability of being here, which when I say her, I mean the alleged victim. That's in the case MRE 804B. The circuit court interpreted MCL 76827C as requiring that first the victim must be declared unavailable, then only then can you use the exception to hearsay. The court then concluded that because the complainant was not declared unavailable, the exception did not apply. That's in the case of People versus Olney, 327 Mission Act 319.
Did that case go to the Court of Appeals after it left the circuit court?
Yes, Your Honor.
What did they say?
The case, furthermore, can I read it?
Yes.
Says the circuit court also held that the exception could not apply because the statements of the complainant are testimonial, and that by not having the complainant there, the confrontational clause of the 6th Amendment was violated. Furthermore, the exception to the hearsay rule found in MCL 768 extends on MRE 804B, and you must first get past the confrontation clause of the 6th Amendment before you can use a hearsay exception. The circuit court granted the motion to quash and dismiss the charges against the defendant. 933 N.W 2D 744 People versus Olney, OLNEY 327 MICH APP 319.
You finished, sir?
Yes, Your Honor.
Okay, so you were making an objection to the testimony of the officers, just so we're clear, correct?
Yes, Your Honor.
As inadmissible hearsay?
Yes, Your Honor.
Okay, did you want to respond to the objection?
I have People v. Olney up, that being 327 Mich. App 319, March 14th, 2019. Literally, the subheading in all bold capitals is, and I quote, "There is no unavailability requirement in MCL 768.27C. Further, confrontation clause does not apply to preliminary examinations. And even if it did, the statements would not be testimonial because it was an ongoing emergency at the time statements were acquired from both Sincere Dunbar and Alicia Ronpool. The only statements so far that would be testimonial were those of Detective Sarah Wilson, and he got to confront her. So, no, to all of it.
And you're, just for the record, your attorney made the same objection that you just made. I don't know if you missed that, as to, 7C, being inadmissible because of the lack of confrontation. The court ruled on that, and the court overruled the, objection, okay? But your objection is noted, and that's based on, and the court ruled it based on the case law, okay?
Yes, ma'am.
Okay, and so there's now a request to continue,
For
because,
Seth Osentoski.
and he's testifying on the two newer files, correct?
Yes, he's the reporting officer on file 24679 FY and 24536 FY. My intention was to have Officer Sean Rotuno, again, have his testimony apply to all of these as he personally is able to identify the defendant as Nathan Joyner, who was in a domestic relationship with Sincere Dunbar that she had a personal protection order against, which I intended to elicit from Officer Seth Osentoski. By that same token, Detective Sarah Wilson's testimony is to apply to all three because it's people's intention, no matter what the court decides with Officer Seth Osentoski, to request additional witness interference charges in all three files.
Oh, counsel.
Yeah. Your Honor, I understand all too well difficulties with witnesses and, sometimes they get served and they appear, sometimes they get served and they don't, and people forget. And all of that to say, I have no objection whatsoever if counsel needs to fall back and regroup. That seems reasonable to me. With respect to his motion, I would simply respond this way. I would respectfully ask the court to hold that motion for additional charges and abeyance until the final conclusion of this proceeding. And then I would be happy to more fully and perhaps a little more intelligently address it if I may.
The motion to add the additional charges is what you're asking about?
Yeah.
Okay, I don't address that until the end anyway, so it would be held in abeyance. Mr. Joyner, you wanted to say something?
I just wanted to ask, could I have a witness testify on my behalf as of now?
Well, you could have a witness testify. They just can't testify right now because the people have to rest first.
Okay.
But you have absolutely every right to call witnesses, okay?
She's here.
Okay, well, she's got to come back on the next date if you want your witness to be called to testify, okay?
Okay.
Because we got to continue this. This was originally a matter that was scheduled for probable cause conference on file number 679. Also possibly why Officer Osentoski may have had some confusion, I don't know. But so is it currently already set for exam next week, or do we remove that? This is all removed. Okay, okay, so you want this set 1 week, or do you need time to subpoena the officer?
The rub is Mr. Freeman and I are going to be starting a criminal sexual assault trial next Friday morning with Judge Aquilina. I do not want my schedule to muck it up. I know Mr. Freeman's schedule very well might because he is the defense attorney. If need be, I will have someone else cover. I do not want my own schedule to be in the way.
Well, if you're both in the same trial, then then there's no way we can do next week.
I know.
So we'll get you the next available date. Sorry?
Next available or?
Well, not next available, because that might be July. Where can we put it?
I was gonna ask Constance if
She doesn't want to come in.
there's a chance that they can add any more to the.
Look, I've had to do this with her before, I know. That's just a
late.
Next.
She took off to go
What
see
should have
Dr.
been, it
Phil.
would be
to go
next
film with Dr.
week.
Phil.
No, they can't put anybody else on here.
Welcome
Even
to
if
my
they,
world.
if they can, it doesn't mean we can't add anybody.
Yeah.
Well, I mean,
That's
like,
right.
just so like, because if they don't, I mean, that would be good.
No, that's the
Like,
rub.
if it just
That's
stays like this, then we can add it here. But if it
Oh,
leaves up,
showed up to my court dates on time. I live here in the city of Lansing, Michigan. I have an 11-year-old and a 17-year-old son and a daughter that lives here in Michigan. I've never stepped foot out of the United States once in my life. As far as my prior convictions, I have no violent convictions on my record besides the weapon charges that I stated briefly earlier. And I served my debt to society for that in 2009 to 2011. I'm not on parole or probation. As far as my occupation, I'm a bricklayer apprentice for Courtroom Construction. I'm in the local tool union. I'm a local tool union hall member out of Lansing and currently up to date on all of my dues. I'm in great standards with the union. I understand the seriousness of all the alleged allegations that put the impression to the court that I'm a threat to society, but to my understanding in the United States of America, it is a principle that I'm innocent until proven guilty and not the other way around. And I feel like I'm getting treated as I'm guilty and not innocent. And I just ask for a fair bond.
Thank you. If you want to respond to the bond motion.
I've literally presented today evidence that he has been violating the bonds and attempts to interfere with the judicial system. I don't think that there's anything else I need to say.
Your Honor, to object to that, I spoke about the time and dates of those messages being prior before the new charges brought up amongst me, and I wasn't aware of them. I was not aware of the new charges that was being brought on me. I thought I was coming to court one day and they arraigned me for new charges, and that happened twice.
Okay, thank you.
Thank you.
Okay, well, let's see, file number 24-00679 FY, there's a bond of $20,000 cash surety. Bond in file number 24-00536 FY is 75,000 cash surety. And then bond in 24-00106, bond is set at 100,000 cash surety. There is a victim in each of these files. Let's see, I don't believe I arranged you on either of these. That means that the arraigning officer, which I believe in one was a magistrate Milmore, one you were arraigned by Judge Buchanan, and the other one, it looks like you were arraigned by Judge Ward. At that time, they would have had more information before them than I have now, because they would have had your criminal history before them. Nonetheless, I do have a bond recommendation, and I know the allegations that are alleged. There's a home invasion, first offense, first degree, felony, 20 years is the maximum penalty and or $5,000. Habitual offender fourth offense notice, however, enhances that to a life offense. In the other file, the 679, you are charged with a unlawful imprisonment, 15 years and or $20,000 is the maximum penalty. Or it says a assault with intent to do great bodily harm, less than murder or by strangulation, felony 10 years or $5,000. Interfering with a crime report, committing a crime and threatening to kill or injure, that is a felony, maximum penalty 10 years and or $20,000. Another, interfering with electronic communications, that's felony 2 years and or $1,000. There's count 5 and count 6 of domestic violence. Both of those are misdemeanors. However, there's an habitual offender fourth offense notice on this file. And so that would enhance the primary offense in this matter to making this a life if convicted. Other file ended in 536, you're charged in count 1 with assault with intent to do great bodily harm, less than murder or by strangulation, felony 10 years or $5,000. Count 2 is domestic violence, count 3 domestic violence. Again, there's an habitual offender fourth offense notice, which would enhance the penalty to life. Factors that the court would have considered in addition to the very serious allegations of assaultive action would be that these are crimes that are charged with violence towards another person, that the defendant has a history of violent behavior towards the victim, that there's a history of threatening or harassing behavior toward the victim or the witness, that there were threats to kill the victim or the family, there's been some stalking behavior, at least allegations of that, and that There's a prior domestic violence, prior strangulation, lots of dismissed domestic violence noted on your criminal history. Over 10 prior domestic violence incidences were noted on your prior criminal history. And that there was use of alcohol alleged during the offense in one of the files. And then in addition to that, we now have allegations and testimony to support some of those allegations that there's been some violations of the bond conditions and potential new charges for witness intimidation. I'm also going to note that the court received word today that you were involved in a fight in the jail today. The court is concerned about the public safety and about your ability to not engage in assaultive or threatening behavior. Therefore, the bonds are more than appropriate. And if I were arraigning you now based on this, in addition to understanding the allegations of what took place today in the jail, your bonds would be higher. So the bonds are more than fair. I think it's in your best interest, sir, that you exercise your right to remain silent, because I think you're doing yourself a service. And I've been more than lenient with allowing you to speak because I don't want you to feel like you don't have an opportunity to be heard. But what you're doing in some of your speaking is you're putting your foot in your mouth. You're admitting to things that you don't need to admit to, as to witness intimidation and communication with witnesses. That's never information you need to admit to or talk about or even give rise to the cause that you may have been aware that there were potential actions. And that's for them to prove, and you can remain silent. That's your right. And I heard you talk about some of your rights, and I recognize that you're probably in jail and you're probably studying or getting information from other people about what you should and shouldn't say. Some of this stuff, very inaccurate. Not to say that you said this or not, but if in fact you were to have told somebody who was the victim that they should get a letter to the judge to make a case go away, is the furthest thing from the truth that anybody who's traversed through the criminal system would know. We can't dismiss anything because we get an affidavit. They issue the charge, they get to dismiss the charge without it coming before the court and the court not being able to move the case forward. I can't dismiss it based on those things, but I think that it's in your best interest to try to work with your attorney to formulate your defense. I'm not finished. You have a very well capable, well-versed attorney, regardless of the fact that you don't believe you do. He's very capable, very versed in the law and how to defend you. The fact that you want to formulate your defense is where the problem gives rise. And that can happen with any attorney, because you're going to think you're smarter than the attorney, and you're going to think that you can give yourself the best defense, and that may not be the case.
It's just a failure to communicate with me, Your Honor.
So you don't think you had enough time to communicate prior to?
We don't discuss nothing as far as these cases, these files. We don't have enough time to discuss anything, and that's causing an interruption between me and him, like it happened today. That's why I'm seated here and not there, because we don't have any time to discuss. He's not giving me. I can't speak for him, but I feel as he's too busy to have my best interest at hand, and his loyalty isn't with me, and that's violating my 14th Amendment.
I can assure you his loyalty is with you, because he's defending you, and as he defends you, that's his reputation. Do you think that he wants to come to court and lose cases?
No, Your Honor.
So his loyalty is with you, but it's difficult for you all to work together if you're going back and forth.
Your Honor, I just want to place on the record that he mentioned last court date that Pfeiffer is his friend and colleague. So I feel like that's conflict of interest.
We're all colleagues in the criminal justice system.
I just feel like I'm not getting a fair share. If I'm getting represented by the state is against me. You work for the state, he works for the state, he works for the state. I don't have a fair chance.
You have more than a fair chance when you come in this court. I don't have anything to do with the prosecution. I listen to the facts, and I can guarantee you I am fair and impartial.
Your Honor, have you read the police report?
I asked you earlier, were you familiar with the court rules and the rules of evidence? If you were familiar, you know I don't get to read the police report.
Clearly, his witnesses, Pfeiffer's witnesses, the law officers are leaving out vital evidence, leaving out evidence of their report that they made on the stand.
I don't dispute that there's some evidence that you believe is missing, and there's likely some evidence that was not, that you believe should have been in, there's not, yeah, let me talk, that was not in the police report. But guess what? This is a probable cause hearing. This is not a trial.
I understand.
And so you don't have to put on your defense here.
No, I just want to be able to have my lawyer object to some of the things that, but I don't have.
I get
time
that,
to.
but I think some of the things that you think should be objected to, you're in error about. You're objecting to you. I've heard some of the, that's when I interjected, when you're telling him to object because he wanted to refresh the officer's recollection by giving him the police report completely within the court rules. And you're saying you need to object because he's coaching. No, he's refreshing the recollection. That's his job. He can't object to that. But you think he can because you think you know more than the lawyers.
I don't think I know more than the lawyer. I just know what happened and what didn't happen.
I know that you do, but this is not the time for you to distract your attorney while he's trying to hear and see what's going on. He knows when he's supposed to object, and he can't object when the prosecutor is refreshing their witness's recollection. Same way, when it's his turn to refresh his witness's recollection, it wouldn't be appropriate for him to object.
I apologize, Your Honor. I just feel like all of these allegations are lies. And like you said, I have prior domestic charges, arrests. I have been lied on a lot. I don't have a domestic violence conviction on my record. So I'm being treated as I do, and that's not fair. I'm not a domestic person. I have sisters, I have
a violent person, not a violent person.
I'm not violent. I'm in the union. We have rules. We go by safety first and foremost. That's our number one rule. If I'm disciplined enough to work my job and be in the union, I feel like I'm disciplined enough to live the civil freedom, have my freedom. And I'm in more threat being in jail, like you mentioned today, fighting.
I don't want you to get into that. I said there was an allegation that you were involved in the fight. And I'm going to stop you from talking because I don't want you to say anything that could be used against you because I don't know if there's going to be charges brought as a result, it relates to whatever happened or didn't happen in the jail. Okay?
That's why I want to get out of jail, Your Honor.
I recognize your interest and your concern about why you want to get out of jail. I think that the judges who set those bonds made bonds based on the recommendations and the information provided to them. And I think that they were more than appropriately set and the bonds will be continued as set. So you would have to work with the bondsman so that you can be released if that's what you want to do.
So total, how much is it total?
You have 100,000 cash surety on one, 20,000 cash surety on another, 75,000 cash surety on the other, and you'd have to work with the bondsman as to what the fee would be for that.
195,000, am I correct?
That's what a bonds or cash surety would have to put up, correct? You have any other questions about that?
Is it tether? I've been in jail for
There's already a
days.
tether order with that. There's not going to be or tether. You're going to post the bond and tether. And that's on each file.
It's my understanding my next court date is when?
That's going to be April 11th at 1:30. Correct.
Can I allow my attorney to add my witnesses?
You absolutely should be talking to your attorney about the witnesses that you want called that you believe can help formulate your defense. Understanding that it's still his job to decide what's in your best interest as what's going forward. And I think today he's been quiet now, allowing you to say some things that weren't very helpful for you.
I apologize, Mr. Freeman, and I apologize to the court. I'm just scared for my life. Like
I can imagine.
Facing life with these allegations, that's not true. And I feel like I gotta speak up for my life. I got kids, I got a family that loves me, and I love myself. And I don't want to just give myself up to the courts and to the system. 36 years old, I came a long way, and I feel like I'm not getting treated fair behind the system. That's all, and I apologize for speaking up out of term and
you don't need to apologize for speaking up for yourself, but you do need to do better with working with your attorney. And I'm sure that Mr. Freeman's going to do better after hearing this with meeting with you, so that you guys can formulate whatever defenses you believe need to be brought forth. But understanding that this is a preliminary examination, some of the things that you're talking about may not be appropriately brought forth during this stage, okay? And Mr. Freeman would know that. He would know if there are certain motions that need to be filed at circuit court versus district court. He would know if certain things are better to address a question of fact, which is what you would deal with at trial. We don't deal with questions of fact here. So if what you're saying is opposite of whatever testimony comes in now, that creates, all that does is create a question of fact, which tells us it's got to go to trial. We're just trying to establish if there's probable cause at this stage.
Start leaving out facts, but making sure they say what they want to say as far as things that incriminate you. They're leaving out facts that will help you.
I understand that, and you talk to your attorney about what those facts are and how you can formulate your defense as it relates to that, okay? Any additional matters for the record?
No, Your Honor, the people have nothing further.
Thank you. We're off the record.
Thank you, Your Honor.
Do you mind if I hug my loved one?
I don't believe that that would be appropriate.
There's one that wants a transcript.